Punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution to SAPD for drug testing.
Welcome to the Court of Justice.
Mr. Horton, did you review the document entitled Application for Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented? Are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Horton, did you review the document entitled Court Admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 2, less than 1 gram, as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yeah.
If you have a plea bargain agreement with the state, the
Yeah.
court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I do.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Horton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
I couldn't hear him.
I'm sorry, has anyone threatened you, coerced you, or
No,
placed you in
no.
fear to get you to enter the plea?
I'm sorry.
That's okay.
His hearing here.
Oh, no problem. Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Mm-hmm.
Did you understand it?
Yes, ma'am.
All right. Punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, Your
Did you review the waiver of appeal paragraph with your attorney?
Honor. Yeah.
Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Be contained into the.
Any objection?
No objection.
State, you may be excused.
Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? This document?
Yes.
Did you
yes,
review that document with him?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I understand.
Did you understand that today the state will not be calling any witnesses? They're going to proceed with just this document that's been presented to the court. Did you understand that?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to and stipulated to testimony. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's ready to do the community service. As the court knows, this court committed him to lifetime fitness. I think the recovery.
Oh, lifetime recovery.
Lifetime recovery.
All right, lifetime fitness, I'm not doing that for anyone, unless they specifically ask for it.
No, you came back in great shape. I don't-
Yeah, you did.
Yes, lifetime, okay. I'll just get past that part. We're aware there's some conditions there with respect to, he's got a hernia right now, and I guess they can take care of him on the community service side. Now, this case has had so many different cases. I want to make sure I know where an order is and that I do address it. His son is here today. He is, to this point, I told him to take the position to stay away from the son because at one time there were some protective orders, and they might still be true today, and I think they probably are. His son is here, and his son wants him at home. He's available to talk to Corey if he'd like to. And this man is sober and cleaned up, and he's ready to go home and be able to be with his son. If you'd like to talk to him, he's available.
All right. How long have you, well, let me have you, well, you've already been sworn in. How long have you been sober?
Going on 6 months on the 22nd.
All right, and what were your issues with your son that involved a protective order?
I drank a lot of beer.
Okay.
I,
No, that's one for you.
No, I'm glad you're being honest.
yeah,
So you've been at Lifetime Recovery. Are you still at Lifetime Recovery?
no, I go to Club 12 now.
Okay.
I'm gonna be a member there.
Oh, that is awesome.
He's
So,
got and I think it's 128 days he has to go every day.
all right, where are you currently living though?
11302 High.
No. I mean, is it a
My
sober
house,
at your home?
yes.
And if I could, I'd just put in, while he's been there, his husband, his son has been staying with someone else.
Okay.
Because he went into that house when he came out of Lifetime about a week ago. And he went there and his son went out.
All right, and what's your son's name?
Jacob Horton.
So I'm assuming there's a protective order in place because you say because it was drinking. Now, there are a lot of people who drink, sometimes to intoxication at their home, but it doesn't result in a protective order. So. counsel-
That's what I was thinking. It may have been a condition of bond, or it may have been something got linked up from the days of the protective order on the misdemeanor, whatever the misdemeanor was.
All right, family violence or criminal
was-
trial division, does anybody know about a protective order he has where his son is Jacob Horton?
I think it may have been a condition of.
I don't know.
There was a misdemeanor for violating the protective. I think that's what it came from.
Well, what I can tell you, if the misdemeanor court, if there's a protective order there, you probably need to take it up with the misdemeanor court judge.
And I don't think they have.
No,
I'll check into it for him.
I've already cleared up all my cases. This is the only case I have.
And if that is the case, I'll verify this afternoon then.
Well, it's just that sometimes when there's a protective order, it doesn't matter if your criminal case has been cleared up because
Right.
protective orders are civil.
I agree.
Yeah.
And I wasn't
So,
sure if there was one.
I don't know if there's one pending or not, but what I can tell you is I'm not going to allow your son to stay with you if there's a protective order out there. That's a hearing for another day.
And I will hustle up and find it.
Okay.
Okay. Please remember, sometimes on that soul stuff, they don't
Well,
invite us.
can I go ahead and just do my 6 months in jail? I'd rather go ahead and just go to jail and get it over with.
Mhm.
I'd rather do that, ma'am.
Well, let me
Because
just
my son and me,
Let me explain something to you.
he doesn't have
even-
any place to go.
Here's the thing.
He's
let-
got his brother, but his brother doesn't like him.
Don't interrupt the judge.
All right, so this is what you need to listen. And I want you to internalize what I'm saying. It doesn't matter if you were to get 6 months in this case and go and do your 6 months time, you know what would still happen? If there is a civil protective order out there, when you got out of jail, that protective order would still be there and you all still would not be able to live together. That protective order doesn't have anything to do with the 187th District Court. It's a civil matter. A civil court probably enacted that. This case is a possession less than a gram case.
Okay,
I didn't put a protective order on, for you against your son or whatever, because this is a drug case. And there's nothing that would have come to me through a police report that suggests that that you even have children. This police report doesn't mention anything about you having children. All it mentions is that you were day drinking. So,
And by the way, Your Honor, he's said this several times, with so many other cases running around, I've never been able to determine that myself. But I can go to the civil side and I think I should, and find out how I can advise my client on that. But with respect to this court, as I understand it, there will be no order of
well, what I can tell you is,
if it happens.
if there is a civil protective order, and if he violates that, guess what? I'm gonna get a motion to revoke, and it's gonna say that he broke the law.
No, I got time served on that charge, so that protective order went away as soon as I got time served.
Okay, here's the thing. Those are two separate matters.
I know it was a misdemeanor court 11, and the judge, he gave me credit for time served.
All right, so, but let me just tell you. Protective orders are civil. They're not necessarily criminal. They only become criminal when people are violating them. Then you can get a criminal case for violation of a bond or protective order. But they are civil in nature.
But whenever I got the assault family bond with my son, they put a protective order.
Yeah. So that has absolutely nothing to do with
And they
this.
signed an affidavit of non-prosecution. I never actually assaulted him, but I was drunk and I was a fool.
Your Honor, if I could, I think what I need to do is, I think you can go through with this. And we've requested not to have that condition here, but we have to honor the conditions of a family court. I will do that for him and advise him specifically if there is or is not one.
Okay.
Daniel, like you said, Texas, I'm thinking honestly, I'm not seeing anything on the protective order. I just see the violation of bond. I feel protective order case that's currently open. Not seeing the protective order. I'm trying to ask if some protective orders can verify that.
Yeah. And so, and that violation bond protective order, that's a misdemeanor court.
Yes, sir.
So that needs to be handled with the misdemeanor court.
So I just don't know if there's an actual protective order that's not verified.
And I think that, if they did, I think they closed.
All right. So are you employed, sir? Are
Yeah.
you employed?
No, I'm retired.
All right. Retired from what?
63 years old. I'm retired. I worked.
No,
at-
I mean, what did you do in
I
your past
worked at
life?
a restaurant for 14 years, but I can't work with a hernia right now.
Okay.
I got it in the county jail.
All right. The court then will find you guilty. Court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's a $2,000 fine. That will be probated. Restitution to SAPD for drug testing. $150 of community service restitution. And if he brings me proof of the herniated disc that he can't do community service hours, I'll figure out something else.
Okay. Oh,
There's going to be daily sober support meetings until further notice. Proof of employment or disability within 60 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Make sure he's tested for alcohol. Field visits. 1 time per month until further notice. Probation, is there anything else?
Would you like us to do a tap?
Yes.
Nothing else, John.
Okay, TAP evaluation. Follow all TAP recommendations. And probation, if TAP recommends inpatient treatment. We'll start with outpatient treatment. Is there anything else you need from the court to be successful?
Do you need anything else from her to be successful?
No, I really appreciate you having the opportunity to send me over there because the program is an excellent place to get recovery.
Oh, I'm so glad. I think it's a
It
great,
changed my life and my outlook on everything. So I've internally accepted that I can't drink. So that's a big plus for me.
all right, awesome. And if you ever feel like drinking, that's why you pick up the phone and you call somebody, okay? Even if it's to call probation and let them know. All right?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? You need to say yes or no for the record.
Yes,
All right, did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
yes.
All right, good luck to you. Probation is going to go over conditions with you. And once she's gone over conditions with you, you're free to leave.
The courtroom tension is palpable as the case of the state of Texas versus John Mark Horton begins. Facing a state jail felony for possession of a controlled substance, Horton stands before the formidable Judge Stephanie Boyd. After a thorough review of the plea documents and confirming Horton's understanding of his rights, the proceedings move swiftly. Horton enters a plea of no contest, relying on a plea bargain agreement that recommends community supervision. But the real drama begins at sentencing. Horton's attorney makes a brief plea for mercy, stating his client is sober, has cleaned up his life, and wants to be present for his son. Horton himself claims 6 months of sobriety. However, Judge Boyd is not moved by appeals to emotion alone. She finds Horton guilty and then proceeds to systematically dismantle any illusion of an easy probation. In a powerful display of judicial authority, Judge Boyd sentences Horton to 2 years in a state jail facility, but suspends it, placing him on a crushing 3-year probation. The terms are relentless. A 2000